Hello there again. This is the Basic Framework Part 2. In this part, I'm going to whisk you through executive and judicial. Now, if you have not watched the legislative in the beginning of the framework and why we have the framework, go back and watch that. Pause this, new tab. Go watch that, and then come back here, and then you'll be all caught up in everything. There's 9 videos in this series, so if you haven't, this is the part 2 of the basic framework. So if you haven't watched the one on the beginning and why the Constitution is the way it is, I highly encourage you to do so. Now, in this video, we're going to start with Article 2, Section 1, which creates the executive. The executive power shall be vested in the President of the United States of America. He shall hold his office during the term of 4 years, and together with the Vice President, chosen for the same term, be elected as follows. And this section creates the Electoral College. Now, part of this has changed, and part of this has become different. Now, this part is the same. Each state shall appoint in such manner as the legislature thereof may direct a number of electors equal to the whole number of senators and representatives to which the state may be entitled in Congress, but no senator or representative or person holding an office of trust or profit under the United States shall be appointed an elector. Now, this is the part that's different. In the beginning, and they changed this very soon thereafter, in the beginning, when someone ran for president and vice president, they didn't run on a double ticket like they do now, like Obama Biden in 2012. Here's what happened. The person who did not become president became vice president. In other words, the person with the next most number of votes in the Electoral College, which means, take the year 2000, for example. When George Bush became president, and a different day and time, Al Gore would have been his vice president because Al Gore had the next number of votes in the Electoral College. This is very awkward, and it's very difficult to get your vice president on board with your agenda when he was running on a different agenda, and in the case of the creation of political parties, which happened literally during the time that the ink on the Constitution was drying, very difficult to get your party's agenda in through Congress. So this was changed, and I believe by the election of 1804, it had changed. Congress will determine the time choosing the electors and the day on which they shall give their votes, which day shall be the same throughout the United States. Now, throughout Article 2, which is shorter than Article 1, it basically outlines the duties for President. In terms of he shall receive a compensation, it states the oath, I do solemnly swear or affirm that I will faithfully execute the office of President of the United States. I will do the best of my ability to preserve, protect, and defend the Constitution. It says that no person except a natural-born citizen or a citizen of the United States at the time of the adoption of this Constitution shall be eligible. It also sets up how the order of succession in case the President becomes disabled, which usually goes President, Vice President, Pro Tem of the Senate, Speaker of the House, Secretary of State. And usually thereafter, then the person appointed will usually, in the case of death, fulfill the term and then run for a term of their own, if they choose to. Sometimes they don't. In Section 2, it says, well, the President should be the Commander-in-Chief of the Army and Navy and the militia of the several states. He may require an opinion in writing of the principal officer of each of the executive departments upon any subject relating to the duties of their respective offices, and shall have the power to grant reprieves and pardons for offenses against the United States, except in cases of impeachment. He shall have the power, by the advice and consent of the Senate, to make treaties, provided 2/3 of the senators present concur, and he shall nominate, by and with the advice and the consent of the Senate, appoint ambassadors and other public ministers and consuls, judges of the Supreme Court, and all other established by law. Congress may by law thus the appointment of such inferior officers as they think proper in the President alone, in the courts of law, or in the heads of departments. And it also gives them the power to fill vacancies that may happen during the recess of the Senate by granting commissions which will expire at the end of their next session. Section 3 says that he should receive ambassadors and public ministers, take care that laws are executed, and every year deliver what we now call the State of the Union Address. And on Section 4 it says that the President, Vice President, and all civil officers of the United States can be removed from office by impeachment and conviction of treason, bribery, or other high crimes and misdemeanors. The executive is given very little actual power, although as time has gone on, that has changed. The presidents have always been very interesting individuals. In fact, on the History Channel a couple years ago, there was a show called The Presidents, and it was fascinating because it actually went through some of the more interesting characters, like President Buchanan, who was our first fairly openly gay president, or very famously Abraham Lincoln, who lost 8 elections before he ever won anything and had a condition, a deformity on one side of his face. And was a circuit writing lawyer, came from a very poor condition, and learned law by reading a law book and law dictionary. So that they've always been very interesting people. Some of them rich, some of them poor. It's just always been an eclectic group of people. There were some members of the executive who specifically worked harder to enlarge the power of the presidency. Among these, Teddy Roosevelt certainly is one. He definitely enlarged the power of the executive. FDR definitely expanded the power of the executive in terms of getting new programs through Congress and changing the whole fabric of nature of how all of this sort of thing goes down. FDR, I think, was the most unique of the presidents because he spoke directly to the people more often in the State of the Union address, and he, to some greater or less degree, kind of befriended the whole country. And I always felt like that was incredibly interesting, because never before in American history until that time had that really occurred. But once it had happened, it kind of became the standard by which everyone else was judged. And I always felt that to be rather fascinating. So that is that's a bit about the presidents. One of these days I will actually talk about all the presidents, perhaps maybe whisk us through all of those in a hurry, and go from there. But you should watch that series if you have a chance. And there are excellent presidential biographies, so avail yourself of those. Article 3 establishes the judiciary, and it creates the Supreme Court and gives them the power to create such inferior courts as the Congress shall from time to time ordain and establish. They shall hold their offices during good behavior and shall at stated times receive for their services a compensation which shall not be diminished during their continuance in office. The judicial power shall extend in all cases in law and equity arising under this Constitution, the laws of the United States, and treaties made or which shall be made under their authority, to all cases affecting ambassadors or other public ministers or consuls, to all cases of admiralty and maritime jurisdiction, and to controversies to which the United States shall be a party, to controversies between two or more states, between a state and the citizens of another state, between citizens of different states, and between citizens of the same state claiming lands under grants of different states, and between a state or the citizens thereof and foreign states, citizens, or subjects, in all cases affecting ambassadors or public ministers or consuls, and those to which a state shall be party, the Supreme Court shall have original jurisdiction. Now, although the Supreme Court has become unabashedly the final say and authority in all matters constitutional established by the Jay Court in 1800. The Supreme Court actually has very little original jurisdiction. What that means is there are very few cases that start, begin, and end at the Supreme Court. Article 3 spells this out very clearly, that it really has to do with arguments between states and to do with basically any foreign person, foreign ambassadors, or between nations. The Supreme Court has the original jurisdiction. Otherwise, things begin in lower courts. These lower courts, what we call federal courts, are organized in what are called circuits. Now, justices before 1889 actually had to go out and go along the circuit and consult with the lower judges on their cases. However, it was deemed there might be a conflict of interest, and so now that they no longer do that. But there are 13 circuits. The Supreme Court justices preside over those 13 circuits and provide advice and or stop cases and do a variety of other small legal things that you'll hear about from time to time when something goes before a certain circuit. So each part of the country has their own circuit, and they all report up to the Supreme Court. Now, the creation of these courts only applies to federal laws, only applies to federal crimes, and oftentimes when an injustice has occurred, the fastest way to get some additional oversight is to take it to a federal court. This is one of the most, I think, important parts of the Constitution, because in the Federalist Papers way back in the beginning, they talked about ensuring justice. One of the important things the federal government does via the Supreme Court and the federal judiciary is make sure that the states stay honest. And by giving people a recourse at kind of a greater level in case a state isn't honest. And in matters of civil rights, murder, social change, this power has been paramount in order to kind of create change at a big national level in a big important way. We've seen this with gay marriage, abortion, segregation, school integration. When it comes time for these things to occur, it is oftentimes far easier to get those things in a federal court than any kind of state courts. The states have their own powers to establish their own courts, and they all do. All states have their own state Supreme Court and lower courts in a similar system to the federal court. They usually don't have circuits. States don't have need for all that, but there is a similar kind of level of courts starting at the municipal and kind of spiraling up from there, with usually the state Supreme Court being the final say for any kind of state laws. If there is a constitutional matter or a federal court accepts a motion of something being unconstitutional, that's usually when you move into the federal system, and that's when you will get you begin to get to the Supreme Court. So, for example, with gay marriage, it started with the gay marriage ban being deemed unconstitutional. The motion was that it was unconstitutional, therefore the law was unenforceable. The federal circuit accepted it, and then it got to the Supreme Court. And so that became the Obergefell decision, and that allowed gay marriage throughout the country, striking down all state gay marriage bans, deeming them unconstitutional. Same thing with Brown versus Kansas State Board of Education. And that's how these kind of very famous seminal cases become famous cases, as they end up in the federal court system. So that is what establishes the federal court system and how this all goes down. So that's the basic framework of the U.S. Constitution. That's the nuts and bolts. That's basically how things work. Article 4 is kind of a holdover to Article 5, which has to do with amendments, which is the next video, but I'm going to whisk you through the end of Article 4. It basically covers a guarantee of a republic, establishes the full faith and credit of the United States, including dealing with debt from the Revolutionary War, and given to every state to the public acts, records, and judicial proceedings of every other state, that basically the federal government shall be honest, and that Congress can prescribe manner in which things shall occur. Section 2, the citizens of each state shall be entitled to all privileges and immunities and citizens of the several states. A person charged in a state with treason, felony, or other crime who shall flee from justice and be found in another state shall be on demand on the executive authority of the state from which he fled to be delivered up and removed from the state having jurisdiction of the crime. No person held to service or labor in one state under the laws thereof, escaping another, shall, in consequence of any law or regulation therein, be discharged from such service or labor, but shall be delivered up on claim of the property to whom such service or labor may be due, which they actually use to justify border crossing of finding free slaves in the North from the South, beginning in 1845 through the Civil War. And then Section 3 discusses that new states shall be admitted by Congress into this union, and no new state shall be formed or erected within the jurisdiction of any other state. We will get to Article 5 and the amendments in the next video and go over all the fun amendments and what they do, things they changed or modified, now that you have the basic framework down. So, this has been fun. Feel free to email in with questions. Email at CameronCowan.net. On Twitter, at Cameron Cowan on Twitter, and Facebook.com/The Cameron Cowan Show. I look forward to all your questions, and I will see you when we talk about amending and the amendments.